I welcome you all to lecture number 9 in Sale of Goods Act in CA Foundation lecture series sponsored by Shujendra Rangzon. I'm your mentor Shekhar Gehlot. We are now on performance of contract of sale. Till now we have discussed different facets of Sale of Goods Act and how sale has to be done, how transfer in property of goods take place, and all other relevant infos such as warranties and guarantees and when sale cannot be operated. Now we'll read about another facet of Sale of Goods Act which talks about performance of the contract of sale. Give it a quick look and then we'll discuss about it. Now, delivery, we are on performance of the contract of sale. How the sale of contract of sale is to be performed. First thing here is definition of delivery. So, what do we understand by delivery? Let us read. Delivery means voluntary transfer of possession from one person to another. Now, the word highlighted here is voluntary transfer. Okay, voluntary transfer means transfer has to be by choice. Okay, the transfer cannot come up by snatching or by threatening someone under coercion to part with the property. Okay, this will not be considered to be a valid delivery of property in the goods, though it may be a delivery of goods. Okay, but it won't constitute a valid delivery as per the Sale of Goods Act. It will merely be a delivery of possession, not the delivery of ownership. Here we are dealing in the Sale of Goods Act, we are dealing with the delivery of ownership of the goods, not mere delivery of possession. Thus, if possession is taken through unfair means, there is no delivery of goods, like we just discussed. Delivery of goods sold may be made by doing anything, okay, anything which parties agree shall be treated as delivery or putting the goods in possession of the buyer or of any person authorized to hold them on his behalf. So, now how delivery can be effected? How will you effect a delivery? How will you perform a delivery? This act replies to that you do anything whichever is agreed between you, and upon doing that thing the delivery will be complete. Okay, so when a seller keeps some goods aside in his shop, okay, when a seller keeps some good aside in his shop upon the insistence of buyer, it is a voluntary delivery of goods. Okay, when some goods are kept aside, I went to a shop and I say I want to purchase something. Okay, and then I he says okay, purchase is done, I'll sell you. Now the contract is complete and I tell him that you keep these goods aside in your shop only. Now, before the delivery, the goods belong to the seller. Before the sale, goods belong to the seller. They were put in his shop. They were placed in his shop. Now, even after the sale, goods are still in the shop of the owner. But now they belong to me. Now they belong to me because the transfer in the property of goods, delivery of the property has happened through act agreed by both of us. What is the act agreed by both of us? You put them aside in your shop only. So that is how a delivery may take place. Act does not prescribe that delivery has to be a formal one where you have to deliver the goods to somebody's house or shop or office. No, merely by putting a mark on the goods, the delivery can be complete. I go to a cotton bales factory and I put some mark on one bale of cotton. Now the bale of cotton belongs to me. The delivery has happened. The property has taken place. Transfer of property has taken place. Now it is up to me when I want to physically remove this and take it to my shop, or I may sell it from then and there as well. Okay. So delivery will take place as per the act, doing of any act by the parties which is agreed. Okay, any act, it may be any act. Duties of seller and buyer. Now we will read about what are the duties which are cast upon sellers and buyers by the Sale of Goods Act. Okay, it is the duty of seller to deliver the goods and the buyer to accept and pay for them in accordance with the terms of contract of sale. Now, there are only two duties which are placed upon buyer and seller as of now for performance of contract by Sale of Goods Act. For seller, it is delivery of goods, and for buyer, it is payment for those goods. So, seller is bound to make the delivery, and buyer is bound to pay the price. These are the two duties which is cast upon seller and buyer upon the Sale of Goods Act. Payment and delivery are concurrent conditions. So, what do we understand by the one word concurrent? Concurrent means they should happen at the same point of time. Both should coexist. Both should exist at the same point of time. Like I go to a shop and I buy a cloth, I buy a t-shirt, I pay the price. I will take the delivery simultaneously. I'll make the payment as well. If I do not make the payment, the shop owner will not allow me to take the t-shirt with me. This is the normal mode of sale. Okay, generally this is how sale take place. You take the delivery and you pay the price. That's it. At the same time. Okay. Now let us read unless otherwise agreed. Now it begins with unless otherwise agreed. That means parties could agree otherwise as well. What does it mean? It means that delivery and payment can happen on any other date or time as well. Okay, both delivery and payment can be made at some other time, or both could be made separately. Okay, they may not appear concurrently at all. They may not appear concurrently at all. Delivery and payment of price may not coexist at all. It may happen that delivery is first and then after 2 months payment comes up. Or it may be like payment is coming before and delivery is happening later on. So unless otherwise agreed, no, the contract, now this act is dealing about general contract. It says generally these things appear concurrently. Okay, payment and delivery happen simultaneously, but unless otherwise agreed. Okay, unless otherwise agreed means parties can choose some different mode of delivery, different mode of payment, different time of delivery as well. Delivery of goods and payments of the price are concurrent conditions. That is to say, the seller shall be ready and willing to give possession of the goods to the buyer in exchange for price, and the buyer shall be ready and willing to pay the price in exchange for the possession of goods. This is the general form of contract, how generally sale of goods will take place unless otherwise agreed. Which means the act itself is very much flexible regarding delivery and payment. Act is very flexible. Now let us read the rules regarding delivery of goods. What are the rules regarding delivery of goods? Okay, now the SOGA prescribes the following rules of delivery of goods. Give it a quick look, then we'll proceed ahead. Now it says following are the rules of delivery of goods. Part delivery, buyer to apply for delivery, place of delivery, time of delivery. Okay. Installment deliveries, delivery of wrong quantity, express delivery, goods in possession of third party, delivery to carrier warfinger, deterioration during transit, buyer's right to examine the goods. These are the rules which will determine the delivery of goods, which will regulate the delivery of goods. Now let us read all of them one by one. It goes from section 33 to 41 of the Sale of Goods Act 1930. Delivery as per section 33. Okay. Delivery of goods may be made by doing anything like we discussed, which parties agree shall be treated as delivery or which has the effect of putting the goods in possession of the buyer or any person authorized to hold them on his behalf. Okay. So it does not mean that act has to be done which has the effect of putting the goods in possession. No, this is there is an or. Okay, it means any activity may also be treated as delivery or any act which puts the good in the possession of buyer, it is a delivery or in any person who is authorized to hold the delivery on behalf of buyer. So delivery can be made by three ways. Okay, delivery, three-way delivery is one is putting doing any act. Okay, it may be any act or delivering the possession directly to buyer. Two, or the third way is delivering the goods to any person who is authorized to hold the goods on behalf of buyer, like any agent of the buyer. So the delivery would be complete. Now, effect of part delivery. What is part delivery? Let us read. A delivery of part of goods. Okay, a delivery of part of goods. Part delivery simply means delivering goods in different installments or parts. Like per week, I'll deliver some quantity of it. Okay. Okay. 100 kg of rice to be delivered in 10 weeks with 10 kg each week. That is a part delivery of 10 kg each week. So a delivery of part of goods in progress of the delivery of the whole has same effect. Okay, for the purpose of passing of the property in such goods. So when the part delivery is made, okay, now when the part delivery is, suppose first installment, first installment of 10 kg rice is made. Okay, when the contract or the contract of sale can be divided into parts. Okay, so when the first installment of 10 kg is made, delivery is complete as far as this 10 kg lot is concerned and the sale is concluded. Okay, so whenever a part delivery is made, so whatever part is delivered, delivery of that part is complete and sale of that part is complete. Okay, irrespective of the overall contract. Later on, you may not fulfill your contract. Later on, people may resign their contract. Okay, later on, delivery of rest 80 kgs may not be made, only 20 kgs may be made. So sale in effect of those 20 kgs is complete. Now for those 20 kg, the buyer has become the owner. Transfer of property has taken place as a delivery of part of goods in progress of delivery of whole has the same effect for the purpose of passing of the property in such goods as delivery of whole, just like as if whole contract has been performed. Same is the case with part performance. But a delivery of part goods with the intention of severing it from the whole does not operate as a delivery of remainder. Okay, but a delivery of part of goods with intention to severing it from whole does not operate as delivery of remainder. But it does not mean that other part has also been delivered. Whatever part has been delivered will be delivered. If some part is not delivered, it will be treated as not delivered, non-delivered. Okay. Let us take the example. Certain goods lying at wharf were sold in a lot. Okay, certain goods lying at wharf were sold in a lot. Wharf is kind of go down. The seller instructed the wharfinger Seller instructed the wharfinger to deliver them to buyer who had paid for them, and the buyer thereafter accepted them and took away part. Held this was a delivery of whole. Okay, this was delivery of whole. Why? Because buyer accepted the whole lot but took only part. Okay, so now when he has taken only part of it, it means the whole has been delivered. Okay, the whole has been delivered. Now it does not mean that whatever is remaining with the war finger will not be delivered, and tomorrow war finger will say you have taken the delivery of whole. No, it means only that whatever is still lying with the war finger is lying only at the disposal of buyer. So whenever buyer can order, he can take the rest of the lot, and property in those goods have passed to the buyer. So now risk has passed to the buyer, though the war finger still continues to have a possession of the part remainder, which is now lying with the war finger. Okay, so when you take part delivery, okay, when you take part delivery out of a lot after accepting the whole lot, then the delivery of whole lot is made to you. Delivery means transfer of property has taken place. So now whatever property is lying left with the seller is your property. Okay, now it is your property. Seller cannot do anything to this property. Okay, but if it is with intention, part delivery is made with the intention of keeping it separate from the other delivery, then the delivery of remainder is not deemed to be done. Okay, if you took the part delivery but your intention was to separate it from the other, and you will decide about the whole lot later on, but you say I take the part delivery of these goods, I am satisfied with these goods, but I will decide later on about the rest of the remainder. That means rest of the remainder property is still with the seller and the risk is still with the seller. But if no such intention is expressed, then the part delivery operates as a delivery of whole. Buyer to apply for delivery. Apart from any express contract, the seller of goods is not bound to deliver them until the buyer applies for delivery. Okay. If there is any express contract which mentions all these terms and conditions, okay, then you have to fulfill those terms and conditions. Otherwise, if there is no express condition, seller is not bound to deliver the goods until buyer applies for delivery. Now I go and make a purchase of 100 kg of onions from some seller. Okay, now he is not bound to deliver it unless I ask him, you please deliver it. Because taking possession, taking delivered, transferring it to your location, that is totally upon the buyer. Seller is not bound to deliver it at the address you want to. It is upon the buyer to collect it. Okay, it is upon the buyer to collect it, or he may request the seller that you please arrange the delivery and I'll pay for it. This situation may be there. Otherwise, legally the seller is not bound to make the delivery. Buyer is only entitled to take the delivery, and it is duty upon the buyer to pick the delivery and take it up. Otherwise, seller is not liable. So when you purchase bananas, it's buyer's loss. Okay, so it is buyer's loss in this case. If the fruits rotten out, it is buyer's loss because seller is not bound to make the delivery. It is incumbent upon the buyer to collect the delivery or to make a request to the seller. Otherwise, seller is himself not bound to do that. Place of delivery. Whether it is for the buyer to take possession of the goods or for the seller to send them to the buyer is a question depending on each case of the contract. Okay, now it will depend on the case to case basis whether it is seller who has to send or it is buyer who has to take the possession. It will depend on the case to case. Okay, if there is some written conditions, then you will follow them. If there is no written condition or some agreement, then buyer is bound to take the delivery. Apart from any such contract, goods sold are to be delivered at the place at which they are at the time of sale, and goods agreed to be sold are to be delivered at the place at which they are at the time of the agreement to sell. If not, then in existence at the place at which they are manufactured or produced. Okay, apart from contract, if there is a contract for express delivery, express contract or implied contract for delivering at some location, then seller is bound to deliver or seller is bound to deliver at that place. Otherwise, if there is no such contract, then delivery of goods shall take place at the place only where sale is taking place, or if it is for future goods, then at the place of manufacturing, unless some delivery condition is stipulated. That means it is always a buyer's duty to collect it from the from the place of sale, unless there is some agreement. Okay. A and B enter into contract for sale of car. Okay, the car is at Bombay and parties are at Delhi. Then if there is no contract for delivery, then the delivery must take place at Bombay only. Okay, the delivery will take place at Bombay only. If there is no such contract, that seller will bring the car and deliver it in Delhi. If there is no such contract, then the delivery will automatically be deemed to have taken place in Bombay. It is upon buyer to go and accept the delivery and bring the car to Delhi. Time of delivery. Where under the contract of sale, the seller is bound to send the goods to the buyer, but no time for sending them is fixed. The seller is bound to send them within a reasonable time. Okay, where under a contract of sale. Now, seller is bound because there is some contract. It says that seller will send the goods to buyer. Delivery is cast upon the seller that he will deliver, but time limit is not settled there. So we will always assume that he will make the delivery in the reasonable time. Now what is reasonable time will depend upon the goods to goods. If goods are of perishable nature, then it shall be reasonable time shall be such that goods do not perish out in the transit. Okay, if goods are made for some specific purpose like for wedding season, then it should be delivered in such a time that wedding season does not expire. Okay, so this reasonable time can be different for different type of goods. If some construction is going on, then iron ore and the cement should be sent delivered in such a manner that construction is not hindered or not halted. So reasonable time will depend upon case to case basis as well, whether this requirement, for what requirement you are buying those goods, have been informed to the seller or not. Goods in possession of a third party. Okay, now there may be situation where two people are entering into a contract where goods are actually lying with a third party. Now in this situation, what will be the rule for delivery? Let us see. Where the goods at the time of delivery, at the time of sale, sorry, are in possession of a third person, There is no delivery unless and until such third person acknowledges to the buyer that he holds the goods on his behalf, provided that nothing in this section shall affect the operation of issue or transfer of any document of title to goods. A and B enter into contract for purchase of a car. Okay, now the car is lying at a mechanic's shop. So there won't be any delivery of the car unless till the time mechanic does not acknowledge that now there is a new owner, and when he holds this car in the favor of B. Okay, unless mechanic acknowledges that yes, now I understand that you are the new owner and now I repair this car for your benefit. Till the time this is not acknowledged, or till the time this is not put into the notice of the mechanic by the original seller, the delivery shall not be deemed to have taken place. Okay, but however, this shall not affect the transfer of document of title. But whether mechanic knows it or not, the documents of car could be transferred in the name of buyer, whether or not the third party mechanic in this case is aware of it. Okay, because consent of third party is not required for transfer of ownership, but yes, for transfer of possession third party's consent or his notice is required, because if he is not aware that sale has taken place, definitely he is working under an impression that the goods still belong to the seller, and he will not transfer their physical delivery to someone without the authority of seller. Time for tender of delivery. Demand or tender of delivery may be treated as ineffectual unless made at reasonable hour. Okay, what is reasonable hour is a question of fact. Okay, demand of delivery or tendering of delivery, giving delivery or demanding delivery shall be treated ineffectual. Okay, that demand or tender shall be treated as ineffectual unless made at a reasonable hour. Now, what is the reasonable hour? It depends on the time to time basis. Okay, now suppose for winter holidays, shops are closed, or for some election purposes, elections are going on, shops are closed for 2 to 3 days. Now, within those 2 3 days, which is non working hour, delivery made or demand for delivery shall be ineffectual, or suppose late in the night. So, it depends on case to case basis what is reasonable hour. Expense for delivery. The expense of and incidental to putting the goods in a deliverable state must be borne by the seller in the absence of a contract to the contrary. Okay. Now, whatever is required to put the goods in a deliverable state shall be borne by the seller only, unless there is a contract contrary to it. Okay, unless there is a contract. We are not talking about transport, we are talking about putting them in deliverable state, like packaging of the goods. Okay, this is always duty cast upon the seller, that he shall package the goods in such a way that buyer can take the delivery and buyer can put them in the course of transport. Okay, transport is not cast upon seller, because delivery is the duty of buyer. Delivery will be naturally be made at the place where the goods are lying. So from there to wherever he wants to take the goods, buyer shall be responsible for the cost. But putting them in the deliverable state, it is always upon seller. Delivery for wrong quantity. Okay, now what is the delivery for wrong quantity? Let us see. Where the seller delivers to the buyer a quantity of goods less than he contracted to sell. Okay, where the seller delivers to buyer a quantity of goods less than he contracted to sell, the buyer may reject them, but if the buyer accepts the goods so delivered, he shall pay for them at the contract rate. Okay, if I ordered for 100 kg of rice, but he has delivered instead 70 kg only, so I am now entitled. I can reject the delivery, that I will not accept the delivery. Either you bring 100 or you bring nothing. But if I accept those 70 kg, then I must pay price for that 70 kg at the rate fixed in the contract. Okay. Where the seller delivers to buyer a quantity of goods larger than he contracted to sell. The buyer may accept the goods included in the contract and reject the rest, or he may reject the whole. If the buyer accepts the whole of the goods so delivered, he shall pay for them at the contract rate. Again, just like similar situation, either he take his delivered quantity only and pay for it, or he take whole of the quantity and pay for it. Okay, but in some cases, if the delivery is not separable and he is bound to take the delivery of whole of it, and extra proportion cannot be separated from his proportion, then he can reject the goods as well. Then he can reject the goods as well. Where the seller delivers to buyer the goods he contracted to sell mixed with goods of a different description not included in the contract. The buyer may accept the goods which are accordance with the contract and reject, or may reject the whole. Okay. Now, where the seller delivers the buyer's goods he contracted to sell, okay, are mixed with some other goods, he can take his goods and reject the other goods, or he may reject the whole if both cannot be separated. If both cannot be separated. Now, A ordered sanitizers with 5% methanol in them. The seller sends the goods with 4% methanol and 1% ethyl alcohol. Now, he definitely cannot separate them. Either he has to accept the goods like this only, or he has to reject them whole. Okay, or sometimes there may be contracts many times which are separable, so he can keep his product and reject the other product. But if some issue is like this which has cropped up where he cannot separate the mixture, then he has to send it back. The provision of this section are subject to any usage of trade, special agreement, or course of dealing between the parties. That means whatever is the customary practices, whatever are the business practices of the parties, they shall have overriding effect over these provisions. That means whatever tradition the parties are following, they shall be given due accordance by the law, and these conditions of delivery shall be subservient to those. Okay. A agrees to sell 100 quintals of wheat to B at 1000 per quintal. Okay. A agrees to sell 100 quintals of wheat to B at 1000 rupees per quintal. A delivers 100 1100 quintals. B may reject the whole lot or accept only 1000 quintals and reject the rest, or accept the whole lot and pay for them at the rate of contract of sale. Next one is installment deliveries. Okay, delivery by way of installment. Unless otherwise agreed. Okay, unless otherwise agreed, whenever this phrase will be used, it shall always mean whenever any act starts, whenever any section will begin with, it's unless otherwise agreed. This phrase shall always mean that the terms and conditions agreed upon by the parties shall be treated on priority than these rules, which means that these rules are only for situations in which the parties do not have any special terms and conditions. Okay, they operate in general platform, but if parties have their own terms and conditions, then those terms and conditions shall be given priority by a court of law rather than these rules. These rules are secondary. The terms and conditions formulated between the parties are primary in nature. Unless otherwise agreed, the buyer is not bound to accept delivery in installments. Okay, if it is agreed, then he will accept the delivery in installments. Otherwise, buyer is not bound to accept the delivery in installments. This is what the rule stipulates, that usually we will not expect a buyer to take or accept the delivery of the lot in installments. But if the parties have agreed that delivery shall be made in installments, then no way delivery can be, then no issues, delivery can be made in installments. But otherwise he is not bound, he can reject. The rights and liabilities in cases of delivery by installments and payments thereon may be determined by the parties of contract. Okay, but if there is no contract, then a buyer can validly refuse to take the delivery of installment and law will be at his side. Seller then cannot drag buyer to the court and say that I made a part delivery and he refused to accept that delivery, because the law says unless otherwise agreed. Okay, if the parties have agreed that the delivery shall be made in installment, then and then only the delivery shall be made in installment. Otherwise no delivery in installment shall be accepted by the buyer. But even in case the buyer wants to accept the delivery, then he can do so. Okay, this is an option for buyer. Delivery to carrier. Okay, now in this section we'll discuss delivery to carrier and deterioration during transit. You give it a moment and then we will discuss it. Now what is delivery to carrier? Carrier is the third party, usually a ship, plane, truck, courier agency, etc. Okay, delivery to carrier. Now when we make a sale, when seller makes a sale, okay, and he has to send the goods to some other location, which is some far away location, okay. Then when he puts them in the he loads them. So whenever he places them with the train, plane, or truck, the delivery is complete. Okay. Okay. So whenever the seller puts it into the course of delivery, okay, whenever he delivers it to plane, ship, or train, because from here train will take it or plane or ship will take it, and seller will have no control over the no control over the goods. So now, for seller's part, delivery to the buyer is complete because he has no control over these modes of transportation. So the normal rule is when the seller puts it into the mode of transformation, okay, mode of transmission, then if the seller has a control over that mode of transmission, like if he has a control over the train or plane or ship from which this material or these goods are being transported, then in that case, if he has a control, then delivery shall not be deemed to have been sufficiently made till the time buyer has not taken it physically. Okay, but if these modes of transmission are not controlled by the seller, like plane, train is not train, no one can control the train other than government of India. Okay, plane, train, or ship, large mode of communication, they are not controlled by sellers usually. So when you put them in that mode of transformation, that means your delivery to the buyer is complete. Delivery to the buyer is complete. Deterioration during transit. Where goods are delivered at a distant place, the liability for deterioration necessarily incidental to. Where goods are delivered at a distant place, the liability for deterioration necessarily incidental to the cause of transit will fall on buyer though the seller agrees to deliver at his own risk. Okay. So now if at a distant place goods are to be delivered, okay, Though seller says that I'll deliver them at my own risk, but still, whatever damage which necessarily will happen, okay, during delivery, which is bound to happen during delivery, not very major damage, but some small damage, some small shift, some small cracking, if it is bound to happen during the transmission, then that will be the liability of buyer only, okay, because goods cannot be transmitted without that particular damage, because that is necessary with that mode of transmission. So whatever will happen will be upon buyer, okay, though seller had agreed at his cost, but it is usually with the buyer. Let us take an example. P sold to Q a certain quantity of iron rods, which was to be sent by proper vessel. Okay, proper vessel means sea vessel. Okay, sea vessel. It was rusted before it reached buyer, because sea vessel takes around 1 to 2 months, okay, for delivery. Sea vessel usually takes 1 to 2 months for delivery. It was rusted before it reached the buyer, okay. So it got rusted. Some rust was accumulated because sea weather is very saline, water is there, and the weather around the sea is always very humid. A lot of humidity, a lot of water in the air is present, so the oxidization happens with the iron and some rust occurred over it, and that is, it has to happen, okay, you cannot prevent it from happening because this is a part of the journey. So it was rusted before it reached the buyer. The rust of the rod was so minimal and was not affecting the merchantable quality. And the rust is minimal, okay, very less rust. It does not affect the merchantable quality. And the deterioration was not necessarily incidental to its transmission. And the deterioration was not necessarily incidental to transmission. It was held that Q was bound to accept the goods. Okay, now in this case, deterioration was not a part of transmission. Still, it was held that Q is bound to accept the goods because the rust was very minimal and the damage was not affecting the merchantable quality of the iron. Buyer's right to examine the goods. Buyer's right to examine the goods. Where goods are delivered to the buyer who has not previously examined them. Okay. Okay. Buyer has a right to examine the goods. Where goods are delivered to buyer. When goods are delivered to buyer. Which buyer? The buyer who has not previously examined them. Okay. So that means if he has previously examined them, then this right will extinguish. This right will no longer be with the buyer. Buyer cannot seek subsequent examination on each and every stage of the process. He can have a reasonable examination only once. He is entitled to a reasonable opportunity to examining them in order to ascertain whether they are in conformity with the contract. Okay, he is entitled to a reasonable opportunity of examining them. Reasonable opportunity must be provided to him to examine the goods, to check the weight of the goods, to check the color of the goods, the size of the good, the quality of the good, the grade of the good. Okay, he has to check everything, the merchantability of the good. He will be given a reasonable opportunity. Unless otherwise agreed, the seller is bound, on request, to afford the buyer a reasonable opportunity of examining the goods. If it is not agreed in advance that no opportunity shall be examined, shall be given to the buyer. If the contract says that buyer shall not be allowed to examine before accepting delivery, then buyer will not be allowed to examine. But if this is not agreed, then buyer shall be entitled to make a reasonable examination of the goods, and seller will be bound to afford such opportunity if the buyer so requests. But if the buyer does not request, seller is not bound himself to open the goods and let the make unnecessary request to the buyer to examine them. It is all upon, it is a buyer's right. If he wants to examine it, he can. If he does not wish to examine and accept the delivery, he can do so. So A sends 100 LED bulbs to B. Now B can reasonably examine any 50 out of it, out of the lot. Okay, whatever he wish to. It is not that he will examine each and every bulb. Okay, he cannot take this much time. He can take only reasonable time. He can very well examine 50 or 60 out of it, and if they are all working, then we can safely assume that all the LED bulbs would be working. He can do a random examination. Okay, so this is, and he, the seller is bound to provide such opportunity. The seller, if the buyer asks that no, I want to examine some bulbs, then the seller cannot say that you examine these 50 bulbs only. No, if the buyer wants to examine randomly from the lot, then the seller is bound to let the buyer examine randomly from the lot. Seller cannot force upon the buyer to check the already decided samples. No, it is upon the buyer to try out and examine whatever bulbs he feel good so.